Henry Quillian. We're here at Taylor English Newman in Atlanta, Georgia. It's our litigation group. This is called Litigation Fundamentals with Henry Quillian. We are lucky to have with us today one of our newer partners here at the firm who has long-term expertise in insurance coverage issues. He has actually been studying insurance coverage since he was an undergrad at the University of Georgia, Tarleton College of Business. So it's rare that people can get excited about insurance coverage because it's hard. You pull your hair out, and a lot of people are just flat out wrong about what they say with respect to insurance coverage because they don't really want to understand and know the ins and outs of it. But David Forestner will be speaking on it, and he has studied it, and I've actually worked with him on 3 matters. I'm very impressed with his capabilities, and we've had some successes, which always makes you feel good about things. For those of you out there in the world watching this video, please recall that though we are a law firm, we are not providing you legal advice. We encourage you to go get your own attorney. These topics are to bring issues to the forefront that need to be addressed in connection with litigation, but also in connection with general business that you might confront, especially if anything having to do with insurance in this instance comes up. So we encourage you to go talk to your own lawyer with a list of questions. And if your lawyer looks at you with a dazed look and grumbles and moans and groans, ask them, hey, can you refer me to a lawyer that actually knows what they're talking about in connection with insurance coverage? Because I can tell you're not comfortable with it, which would be true, I would think, at least 98% of lawyers probably not comfortable with insurance coverage. So with that, let me introduce David Forestner. As mentioned, he is a partner in our litigation group. He's going to be talking about several aspects of insurance coverage, both in connection with litigation and in connection with corporate law. And let's give him a hand.
Thank you all. I'm delighted to be here. As you said, my name is David Forestner, and I've had many years of experience dealing with coverage issues. I was a risk management insurance major at the University of Georgia. Following that, I spent a significant period of time, I don't want to actually go into how many years, as working in insurance claims departments, evaluating coverage and liability for mostly medical malpractice claims in Georgia and Florida. One thing that I've dealt with a lot in the past is late notice of insurance claims. And one thing that can help alleviate those late notices would be for when clients of law firms come to you, and primarily to litigators, that litigator has an obligation to investigate insurance coverage on behalf of their client. That's not something that, in my experience, that we were very adept at big law firms. That was the idea that if we investigated insurance coverage and we found it, we might not be able to handle the case. But that's kind of a moral hazard that we all deal with. But Georgia and most states do require that any litigator, any lawyer investigate insurance coverage on behalf of their client when they're faced with a matter that might be insured. So how do you do that? When they come to you as a litigator, you go ahead and you ask them if they have insurance for the claim, or whatever matter it is, wherever it is in the process. Because the way most policies work is that you have to report an occurrence, not just a claim. And if it's something that might turn into a claim, it needs to be reported. Now, one of the cases that Henry has dealt with is involving a construction matter where a general contractor went to several lawyers relating to notices he received for improper building techniques on a property. And so what happened was one of the complaint letters and request for cure was in 2004, one was in 2006. He was sued in 2008 and did not report the claim until 2008. He completely lost lost coverage under the 4 policies he had because he was aware of an occurrence that might result in a claim back in 2004. So it's important that no matter what stage in the process of the dispute, that claim, occurrence, whatever, be reported to an insurance company if they have it. Now, when you go to your client, you say, hey, do you have insurance for this loss? He's going to say, I don't think so. Well, you better make sure, because the duty is to investigate the existence of insurance coverage, not just to ask your client. Ask if you have a broker, talk to the broker. Don't take the broker's word for it if they have coverage. If they have policies, try to get the policy. We recently had a case where a major company called their broker and said, we have insurance coverage for these claims. The broker said, no, you don't. Well, we got the policies, and we determined that there was coverage for those types of losses. It would have made a huge difference in how the expenses were allocated in the case. Joe?
Is defendant's counsel required to inform plaintiff counsel whether the defendant has insurance?
Federal courts and interrogatories are the only times I understand that that's required. You don't have to tell anybody. It may not be part of your negotiating strategy to let them know that you have a tremendous amount of funds available. But of course, you're going to have to involve the insurance company in that situation, because the case needs to be reported and they need to have input into settlement negotiations if that's what's occurring. It's going to be the option of the insurance company whether to get involved and at what level at that point. So really, if there's some kind of inquiry, that inquiry needs to be passed along to the insurance company. You don't want to prejudice their ability to dispose of the case if they have the option to do so without your permission early on and without having expended a lot of defense costs. So what I would suggest as far as the investigation is go until you feel comfortable investigating the coverage. Make sure you exhaust the sort of resources available to you if you can. The other aspect of this, and what's kind of cautionary thing to tell transactional lawyers is they often get, my transactional friends like to tell me that most of the cases that come in litigation come in through the transactional departments, and that's why all these big law firms are the engine and the heart of those vehicles. And so what I want to caution you about is if you're a transactional lawyer or you're working in a business, when you get a call from a client, not just from somebody, if you get a call from a client and they say, I need a lawyer for something, I've just been sued, you probably have an obligation to investigate insurance coverage if they're your client. We get all these emails. I got a friend in Idaho who needs an attorney. If that's your client that's called you about that, then you need to make sure that they get their insurance coverage investigated. And the best way to do that, for the most part, is just tell them, did you call your insurance company? Did you call your insurance company for this loss? If it's covered, they will give you a lawyer. That's the best way to handle one of those situations. If they say, I don't have insurance, you ask them what kind of insurance they do have, and then try to figure out if they're right about not having insurance. The most valuable part of an insurance policy, for the most part, for most insurers, is the provision of a defense. And if you lose the provision of a defense, that can be financially catastrophic to many companies. So it's important that you investigate that issue, because if they, even if it's your friend, even if it's your client, if they have a catastrophic legal event, they're going to look out for somebody to pay. And even if,
I'm sorry, I hate to interrupt. Do we have an obligation as litigators to review insurance policies and opine whether there is coverage?
I don't know how far you have to go. That's what I do, because I want to make sure for myself. If you have a question, you can ask. But if you have a question about it, just have them report it to the insurance company. It doesn't cost anything. The insurance company will tell you whether they have coverage or not. And your obligation is at an end there. You don't have to litigate a coverage issue.
That's what I'm-
You just have to report it.
That's what I usually say. I think you may have coverage, submit a claim, insurance company, and see where that is.
And then you follow that up with an email.
Are clients reluctant to do so because they are worried about their premiums going up?
They are reluctant to do so if they do not think the case has merit, because they forget how much it costs to defend cases. And so that's something you might want to discuss with your clients, just because you're trying to do what's in their best interest. I have had recently a client refused to report it to his insurance company for two reasons. One, he didn't want to incur an increased premium, and he didn't want to lose control over the defense. That's another one. Yeah.
There are many different kinds of insurance, and one thing I learned recently is that when I ask a company, do you have this kind of, do you have insurance cover, whether it was commercial, general, whatever, and he didn't have any of that. And after I got involved in the case, I learned he had a homeowner's policy that actually covered the business problem he had. And so the caution is, if he says, I don't have any commercial insurance or general insurance like that, you may want to look at other policies as well to find out what might be out there.
Especially if it's an umbrella policy. He has an umbrella policy on top of his homeowner's policy. The odds are there's going to be nooks and crannies of coverage there that aren't excluded under the policy. And that's, the frustrating thing for most people who read insurance policies is you read the beginning and it's, oh wow, everything's covered. And then when you get through all the definitions and the conditions and the exclusions at the end, you don't have any coverage at all, it doesn't seem like. And that's especially true in a recent case we had involving environmental coverage. It was an environmental protection policy that provided almost no environmental claims. And that's why some of our environmental lawyers advise their clients not to buy them. But again, the most important part of those policies is the provision of defense, and an environmental claim that can be a very significant expense. Then one thing I wanted to cover was the damages involved in failure to report a claim on when a lawyer is accused of legal malpractice for doing so. There's a case out of California called Jordache Enterprises versus Brobeck. This was an environmental claim, and the defendant law firm failed to report an environmental claim. There was a late notice defense raised. They eventually obtained most coverage for most of the insurers, but the Supreme Court of California, in their infinite wisdom, decided that even the increased cost to litigate the coverage claims, which they were going to have to do anyway, was due to the insurer's ability to raise a viable defense as to notice. They reduced the claims settlement value with their insurers. They had to pay defense costs for 3 years, and they lost alternative profitable uses for the funds they expended on the defense costs and the additional litigation. So those are the kind of damages you would be facing if you didn't report it to insurer. There was a late notice, and even if they were able to obtain insurance. So one good thing about this in Georgia, for the claim of legal malpractice, failure to report claims, that claim cannot be assigned to the plaintiff in the underlying action. We don't assign legal malpractice claims here. Other states, they allow it. You're not going to have a similar situation where it's almost like a bad faith assignment of a bad faith claim to a plaintiff for failure to settle. There is going to be a bit of a stopgap in Georgia. The problem is that we're not just a Georgia firm. People that call us for counsel and to retain us on very complex matters are often in other states, and the damages can be significant. Henry?
Can you mention that aspect we were talking about the other day about what determines the law that the insurance policy is construed under?
Well,
Given the fact that if you're in Georgia and insured and a Georgia claim, it's not necessarily Georgia law that applies, based on what you're saying.
Well, right. In Georgia, well, choice of law is a very important aspect of what we do in litigating insurance coverage claims. We have to figure out what state to bring the case in because there's different late notice rules, different choice of law rules in different states, and especially like when you talk about Georgia, Georgia's rule is that it's kind of a bastardized lex loci practice rule. It's been watered down to where it's just wherever the policy is approved. That's assumed to be the last act that's required to affect coverage. In Florida, it's a strict lex loci practice rule, whereas you can have it's where the last act occurs to affect coverage, and that can be in the case I worked on at my last firm. It was where the binder was delivered to the broker. That was in New York City, and that was in the case that was in Florida. At the same time, if in the New York's rule is the significant relationships test or the center of gravity test. So that would be where the majority of the operations of the insured are, the insured risk. Well, because the case was brought in Florida, Florida applied New York law because that's where the last act occurred to affect coverage. If the case had been filed in New York, they would have applied Florida law because the insured was, main operations was in Boca Raton, Florida. So it's important to understand where you're going to file a case to determine whose law is going to apply, because you want to make sure that any defect in coverage, that state's law is going to be as favorable as possible. Like for late notice, you don't want to be in Georgia. Georgia's a bad place to have late notice. There is no prejudice that has to be shown for a late notice defense to be effective for an insurer. Whereas, you know, in Pennsylvania, they started, and it's spread around the Northeast, that an insurer needs to show prejudice from the late notice to deny coverage for late notice. And it has to be material and significant prejudice. That's a big difference from Georgia. And if you can get somewhere else to have your late notice evaluated, it's very important to do so. Especially when you have a company that's operating around the country. Has a lot of moving parts in different places. You're going to have a lot of opportunities to change the venue. And if you change the state where you're actually filing the case, choice of law may be different, the law applied may be different, and then the standard will be different under which late notice or any other definition of any policy. There's all kinds of different aspects of that. Yes.
You're exactly right about Georgia. I would just throw in one little caveat about title insurance, in which title insurance policy terms really incorporate a prejudice rule. So if you've got something that smells like title insurance, even if you think that it's late in the game, go ahead and vote.
Well, and the rule for notice is that it's strictly construed. So if the policy does have an escape hatch, they're going to enforce it. And that goes to a lot of the other aspects of the policy as well. So, especially in the aspects of choice of law, most policies don't have a choice of law provision. They used to have a lot of arbitration provisions, but those have kind of fallen out of favor as well.
Having your history as risk management, and let's say you have a company that operates in a bunch of different states or has business relationships with brokers in different states, or a broker that has numerous offices. Have you ever told anybody, well, make sure your policies are delivered to New York so you'll have a better choice of law?
I've told them to not have them delivered in Georgia. I'll give them that.
Okay. That's interesting.
No, yes, we had represented a company called Mark Marietta Materials, and they have operations around the country. We decided to, for most of them, to have the policies delivered to the individual. A lot of them to deliver to individual plants where the law was favorable. It's not because they had different LLCs, and instead of sending the policy one place, we decided to have them sent into different locations. It's a very interesting attempt to get around some of that. Luckily, it was never had to use it. They didn't have any covered losses in any of those areas, but that's not to say they didn't have lots of litigation. You have what's called Lulu, a locally unpopular land use. You're going to attract some attention from the local folks, and they will sue you when all you're trying to do is help their economy by providing big rocks turned into little rocks. Some of the things you have to do to get there, like dynamite, things like that to get them set.
Is there any reason you have to turn in a claim before you even do the thing that's likely going to cause you to be sued? Like, you need to turn in a claim saying, if I bring this lawsuit to collect my debt, I know I'm going to be counterclaimed against, so I'm going to go ahead and give notice that the defendant's going to sue me.
No, the claim has to be made. And most of the insurance policies will have a definition of what a claim is. Your actions, generally, while they're likely to result in a claim, the problem is if you know about the circumstances that is likely to result in a claim, you might want to go ahead and do it anyway, just because what you've got is circumstances that might result in a claim, even though you don't think it's valid.
Because you might have an occurrence.
So you
or
might
at
have
least
an
a claimed occurrence, even if it never even happened. Just because somebody said or thinks that it happened. And that, in connection with like home construction law, there's this thing that commonly is referred to as the Right to Repair Act. There's a recent Georgia case, I think it's Tannenbaum versus Builders Insurance or something. People were getting these notices from the homeowners saying, oh, we've got these defects in the house, we want you to come repair it. And then when they ultimately sued, the insurance company said, oh, well, you knew way back when you got those notices that there was an occurrence, and this is late notice. So.
Well, I think that in Tannenbaum, the interesting part of that was the letters were from an attorney. So that might have been more persuasive to the trial court and court of appeals that they were actually likely to result or possibly might result in. So the last thing I wanted to talk about is about, that relates to coverage is that oftentimes insurance is used to fund indemnification requirements. And they may not be termed that way, but it's part of the lease or sale. The seller or the lessee is required to buy an insurance policy to cover some risks that are foreseen as either likely or catastrophic in some way. And there's a way they want to make sure that that's taken care of due to some lack of capitalization on one side or the other. What I would urge you to do is if you're involved in one of those transactions, make sure that the policy that you are going to, your client is going to purchase or you are asking the other side to purchase covers the risks that you're anticipating or trying to avoid. We recently had an environmental claim that was required under the lease. It had no coverage, for example, and wiped out our lessor. He's now in bankruptcy because there was no insurance that covered that, the contingency that eventually came through. And there's also reps and warranties coverage, representations and warranties coverage. I would urge you to look at that very closely. Most of the times you submit a contract, but they might wipe out significant categories of loss. Make sure that you look at that carefully. If you need someone to look at it for you, we'd be happy to, Henry and I. I've done a lot of, I also do commercial litigation, and most of the litigation I've been involved in is related to breaches of representations and warranties and LLC agreements or other documents. So we have a lot of experience in that. We'd be happy to do that.
Anybody else that got any questions or comments?
Thank you.
People out there watching on the video, don't mind having a shorter video. Come back next month for Litigation Fundamentals with Henry Williams.